Good afternoon and welcome to our webinar, The Pandemic and COBRA Challenges Beyond the Virus. My name is Casey Hope. I'm the Director of Marketing and Communications at Medcom Benefit Solutions, and I really want to thank you for taking time out of your day to join us for this webinar. We certainly hope that it will be as informative as possible. Just to let you know, this webinar is being recorded, and we will be able to send out a copy of the slide deck and a link to the recording after the webinar is over. So if there's any part that you kind of miss, or if you have to jump out on a call, or if you come in just a little bit late, please know that we will be able to send out a copy of the slide deck and a link to the recording after the presentation is over. We will also have a session for Q&A at the very end, as we always do. And to lead this presentation and the Q&A is Medcom Benefit Solutions' Michelle Barkey. She's our senior legal counsel with years experience in covering this compliance law and COBRA law and CDHP law, and also comes to us with a healthcare background as well. Michelle is our resident guru and knowledgeable in all things. So we are certainly lucky to have her with us today. And without any further ado, I'm going to go ahead and turn this over to Michelle. Michelle?
Thank you, Casey, and welcome everyone. Before we get started, I do want to mention a couple of things. First off, we are going into year 2 of COVID, and I hope you're all doing well and holding up. The second thing I want to mention is with all these laws that are coming down, typically when a law is passed, you know, they have the agencies have an opportunity to put questions out for review, and then after they get all the questions back, then they can write some rules and things like this. But with COVID, and because we are doing things so quickly, there was no time for comments or for rule making. So everybody is kind of flying by the seat of their pants in a lot of things. The agencies, which are the Department of Labor and the IRS and the Department of Health and Human Services, have tried to give us some guidance, and they've given us some guidance in certain areas, but not in other areas. So we have been, with a lot of these laws in the last year, kind of left hanging out to dry. So things aren't black and white. They never are in the law, but with COVID, it's even more so. So bear with us as we go through this presentation, and we point out some of the areas where there might be some questions or concerns. Well, the first thing I want to get started with, since we are going to be talking about COBRA in particular today and some of the rules that affected COBRA, the first one we have to go through is the mandatory outbreak period. We cannot talk about COBRA without talking about that. And as you know, the departments, the Treasury, the Department of Labor, and the Department of Health and Human Services, they did this by a rulemaking process that they have in the case of a national emergency. It did not go through Congress. It was just they're making a rule. And basically what they said was the outbreak period was going to be from March the 1st, 2020, and would end 60 days following the end of the national emergency. Questions I get asked all the time is, when does the national emergency end? Well, the national emergency does not end until the president declares the end of the emergency. And neither President Trump nor President Biden have declared that end at this time. This is not to be confused with the public health emergency. The public health emergency is completely separate. It's done by the Department of Health and Human Services when they feel that there's a public health crisis, as they did with COVID, and they get to declare an emergency every 3 months. It goes for 90 days, and then they have to renew it. And actually, the public health emergency has been going since January 27th of 2020 and was once again renewed. But it has nothing to do with the outbreak period. It just has to do with other things like when they've stopped the cruise ships, etc. So we don't know when the 60 days is going to end, when the national emergency is going to end. So it's hard to say when the outbreak period is going to end, or at least it was at the very beginning. Therefore, it's always important to stay tuned to get final dates. Now, normally, as you all know, under COBRA, And a person who loses eligibility and has a qualifying event and loses coverage due to that qualifying event has 60 days to elect COBRA from the date that they received their letter. And then after that, they have 45 days after they've elected to pay the premiums. But under the outbreak period, that doesn't happen. That period between March 1st of 2020 through 60 days past the end of the national emergency is told. That means that that period of time does not count. So after the national emergency, wherever they were within the 60 days or the 45-day election period, or even though those who had already elected COBRA and were paying for COBRA and have a 30-day, have to pay at the first of the month and then have a 30-day grace period, they do not have to pay during this outbreak period. And that's basically what it says. So as you can imagine, it has wreaked a lot of havoc. So basically the qualifying event would result in a loss of coverage. Then they have 60 days to elect COBRA and 45. So let's say, for an example, Tony experienced a qualifying event. Hold on, I have to get rid of. Tony experienced a qualifying event due to termination on March 17th of 2020. Let's say that the national emergency ends on March the 1st of 2021. The outbreak period would then end on April the 30th of 2021. Normally would have to, and she would have until 5/16 of 2020 to elect. So the deadline for COBRA, for Tony to elect this COBRA, has been extended for well over a year. But she would have to make retroactive payments in order to get this coverage reinstated, or she could retro do it and only get coverage for a certain amount of time. So how are we administrating that, or how are the TPAs administrating it? It has been an absolute nightmare. First off, I do want to say that employers are not responsible for paying employee share of the premium during the outbreak period. Some may. And at the beginning, some employers may have thought, well, it's only going to be a little while, so I'll pay it for a little while. And now we're running into a year. We're running into a long time with this outbreak period. And the other thing is, if employers are not responsible for paying the employee's share of the premium, the carriers are not responsible for paying claims during the outbreak period when the premiums are not paid. So those claims are kind of could be considered being held in abyss until individuals decide whether or not they want to elect COBRA or whether or not they want to continue the COBRA coverage. And the TPAs are challenged with how to handle this administratively. Certainly the systems that were established way back when COBRA first came out certainly did not have even thought of something like an outbreak period where coverage would be told. So some employees will have to pay massive amounts of back premiums to bring their account current. We do believe, as is always, if ever a large claim hits, the provider, especially hospitals, will be more than willing to pay the back premiums in order to get that huge bill paid. And providers are finding it difficult as well because they're not getting their claims paid on time and having to go to the individual if the COBRA premiums are not paid. And then it's just kind of wondering, are they going to pay the claim? Are they going to pay COBRA? We don't know. Or did they go elsewhere for their coverage? Did they go to the marketplace? What did they do? And so everything is just kind of held in abyss, and it's really an administrative nightmare. So there's a couple of administrative choices. One was the plan continues to cover the individual, or when the bill from the insurance company comes, the employers didn't want to separate, well, I don't know if these guys paid or these guys paid, so they just paid the full premium amount. And then when the individual didn't pay, they went back to the carrier and said, hey, we want a retroactive premium reimbursement. And sometimes the carriers were willing to do that, sometimes they're not. Some carriers said we only go back 60 days, some said they wouldn't. So, you know, it's still a question of how the carriers are handling this. I think most of them have recognized that they really must do something with the outbreak period, but it is still an administrative nightmare for them as well because they don't know who they've got. And then what happens if during this outbreak period, when the employer wants this retroactive premium because a guy never elected COBRA, but claims have been paid. So this way, I mean, it can happen, but maybe it's not the best. And then the second way is maybe the plan doesn't provide coverage at all. Maybe it is terminated because the systems don't have something that's a pending typically beyond that 60 or 45 days. So maybe it gets terminated, but at the very end of the day, you know, you get to re-elect COBRA if you want without going through that appeal process if it's during the outbreak period. And that would require, rather than the carrier reimbursing premiums, that would require the carrier receiving additional premiums and then going back and paying the claim. That's typically what Medcom does. We started the first way out and then we were having troubles with the carriers. So we kind of went to the, we'll terminate the coverage, send a letter that you're in an outbreak period, and at the end of the outbreak period, or during this outbreak period, you may elect coverage at any time. Even if you're out of the normal COBRA timeframes, there would not be an appeal process and you'll automatically be reinstated. And some carriers are just, or some are just holding it in abyss, just saying, okay, I'm not going to say we're paying it and I'm not going to say we're terminating it. We're just kind of holding it out there and see what happens. And a lot of the systems aren't geared for that. And then what happened is when the, again, like this first scenario, when the carrier bills the employer, they just pay the full amount, not realizing they're paying a full amount for individuals who do not have COBRA. So it really has been an administrative nightmare, and one of these days it might come to an end. Now, remember at the very beginning, I said that there has been some confusion and we always don't know the 100% answers. This is what is causing some confusion at this point. I am of the belief, but I cannot say 100%, that the outbreak period may end on February 28. And the reason being is there's a section in ERISA that says, and that's section 518, and that's under the IRS code 7508AB. And generally it provides that in the case of a national emergency, that the, and a presidentially declared national emergency, as we are in, the Secretaries of Labor and Treasury may prescribe remedies for a period of up to 1 year. So when it says that, I'm thinking that we do have a national emergency. Nobody expected it to go this long or beyond a year, but I think we're coming up to the year that they could do that. There's some that are saying, oh, no, it still goes to 60 days past the end of the national emergency. So we're still trying to get clarification from the IRS and clarification from the Department of Labor. But there is this statute out there, and I just want you to be aware of that so that we continue to look at it. Once we get any definitive answer, we will be posting on our Medcom's blog. Now, we also had IRS notices 2029 and 33 that came out earlier, later towards the mid of 2020, and they really did provide a lot of relief. And the question was basically with the notice 2029 was, we had a lot of FSA plans that might have been non-calendar year plans, and they might have had a termination date or a plan year end date of, let's say, August the 1st. And when the crisis hit and things were shut down, when the national emergency was declared on March the 13th, the question came up, what happens with that FSA money? Because I contributed, I put in a plan so much, and I plan to go to the dentist, or I plan to have an elective surgery, or I plan to have my cataracts removed and use the money to help with my eyes, or I plan to do this, or I plan to do that. And then everything kind of shut down and the money was still there. So for the non-calendar year plans, it really created an issue with the FSAs and the HSAs, or the HRAs rather, and they didn't know what they could do with it. So the government basically said, you know what, we are going to allow you to use the money up until the end of the plan year, or to the end of the calendar year, if the employer so agrees. so that you could then take that money that would have run out in August the 1st and potentially use it to December 31st if your employer agreed to that. And then they also said that in Notice 2033 that there was an increase, and there was going to be from now on an increase in the carryover that would be indexed yearly, and that increase was $550. So they could make, so the plans had the option of increasing the carryovers every year. So again, I think the agencies were all thinking when they did this Notice 2029 that there was no way this national emergency was going to continue, that sooner or later things would open up, and they did in some states. I'm in Florida. We opened up pretty much in July and have been cruising ever since, but there are a lot of states that are still really shut down, and they haven't been as fortunate. And I don't know whether or not this was, I don't think that this was anticipated when this notice came out. They also allowed with Notice 2029 that for the 2020 year, that you could make new elections, you could revoke existing elections, or you could decrease or increase your elections. So that was a lot of fun, especially for FSA administrators and employers deciding whether or not to allow employees to make these choices. But again, these were all changes that really benefited the non-calendar year plans. And with all of these changes, COBRA really did not attach because all the changes that were made would technically be voluntary, and nobody really lost coverage except for those that actually terminated. And there was nothing that said that they could continue in the 2020 year. But then we come to 2021, and what did we realize? COVID is still here. It's still going strong. President Biden has told us to expect it for quite much longer, that it's not going away anytime soon. And that that brought to the government's attention that while we took care of those non-calendar year plans, what happens to those non-calendar year plans that might have terminated towards the end of the year, like October, November, or December, when we thought that we were actually going to be finished, and the calendar year plans? So there was a lot of things going on, but the Consolidated Appropriations Act was passed towards the end of December 28th, I believe, and it also allowed for some additional changes. So the government recognized that we were still reeling from the effects of the coronavirus, and the ICU beds were in short supply in certain areas, and we expected it to get a whole lot worse after the holidays and people visiting and traveling between states to states. So some states they recognized are still on lockdown and cannot access services. And to varying degrees, individuals are afraid to go to the doctors, dentists, vision care specialists, or participate in any elective procedures. We have some brave souls that go out there and don't have any fear. We have others that just really are fearful, and we have to account for that. So the Consolidated Appropriations Act allowed a few things. They just said, okay, and what I liked about this was they recognized that it could continue into 2022 or to the end of this year. So they just took care of it all at the beginning of the year, anticipating that COVID was not going to get any better. So they said, okay, the employers, and this is all employer choice, the employers don't have to agree to any of this. They said they could allow the employees to carry over the unused FSA balances from the plan years ending in 20 or to 2021. So any plan year that ended in 20, you can carry over your balances now into 2021, regardless of the amount remaining, and is available to the end of the 2021 plan year. So it doesn't matter if it's more than the 550 that you would normally be able to carry over. You could carry over the entire amount if you were one that had a rollover. Or if you had a rollover, you can carry the whole thing over. For those with a grace period, they said, okay, we'll just expand the grace period to 12 months. Typically it's 2.5 months, but now they say you can carry over the grace period, we can extend that to 12 months. And then it said, and this one has caused a lot of confusion, we're going to talk about this one. It said the employer may allow participants who terminated in 2020 to continue to receive reimbursements of unused money through the end of the plan year. So anyone who terminated in 2020, if it was a calendar year plan, could use the unused funds until the end of December of 2020. Or if it was a non-calendar year plan and it ended in August, you could use the amounts to the end of the plan year. So, but this is for terminated employees who usually lose the money right up front. And then they said something else with this, which became an issue. The amount, how much can we allow them to carry over? Does it have to be the full election amount? And then the employer would lose monies potentially, because if they terminated in February, but they had elected the full amount and they carried that to December, potentially the employer loses a lot of money because they're not getting paid those premiums or that money. Or is it the contributory amount? And you know what the IRS said? They said it was your choice. So if you want to just allow the employees to take the monies that they contributed, but not the election amount, you can. If you want to be generous and allow them to take the whole election amount, you can do that too, up until the end of the plan year. And then they said that for the DCAP plans, one of the things that happened was we noticed that children were aging out and people had put in money for their 13-year-old, and all of a sudden they age out and the daycares have been closed or the after-school programs. So the DCAP basically said that, if the kid aged out during the pandemic, you can carry over that amount to age 14. They can continue on age 14. Whether that's helpful, I don't know. I don't know how many 14-year-olds really want to go to an after-school care or something like that. But again, it is an option for the employee and their child. So in anticipation, now that was from 2020 to 2021. But in anticipation that COVID is going to be with us a longer period of time, the same applied for the plan years that ended in 2021, that we could still carry it over into 2022. Grace periods were still extended. So we do have a lot of options here, both for this year, for last year carrying over into this year, and this year carrying over into next year. Okay, now let's do some possible scenarios, especially as it relates to COBRA. So here's one of the scenarios that came up. An employer adopts both the carryover provision from 20 to 2021 and the provision that terminated employees can use funds to the end of the plan year. Can the terminated employees carry over the funds into the next plan year? And the answer is, we would say that the answer would be no, because it was very clear that the terminated employees carried over only into the end of the plan year, that they did not have to allow the employees to continue to carry over into the next plan year. So that was based on the actual wording in the CAA that indicated the terminated employees to the end of the plan year and not allowing that carryover into the next plan year. So the second thing was the employees choose the option to allow the carryover of leftovers funds from 2020 to 2021, but did not allow the terminated employees to use the funds to the end of the plan year. The employee did elect COBRA, and how long do they have to use the funds? To the end of 2021 or 18 months, which COBRA normally is. And the answer is it depends. They said that the CAA would allow to the end of the next plan year. However, IRS guidance states that FSAs allowing carryovers for non-COBRA beneficiaries must also allow for similarly situated COBRA beneficiaries subject to the same terms, notwithstanding the special limitation of COBRA. But then it also said that with any carryover in COBRA, you do not have to go beyond the 18 months. So it looks like there may be a choice there, that if you really wanted them to go more than 18 months, I can't imagine this is going to happen very regularly, because most of the plan years will end probably quicker than the 18 months. But it looks like you may be able to allow that COBRA beneficiary, that COBRA eligible person to go beyond that 18 months, or you can terminate it at 18 months. And then they said the employer allowed terminated employees to continue the amount contributed to the end of the plan year. Is COBRA an option? And the answer would be yes, if it was underspent, because there would be a loss of coverage. If you only allowing the contributed amount to the end of the plan year and not the full amount, and if they're underspent on that full amount, COBRA would still be an option because there was still a loss of coverage. And what about an employee who terminates the FSA coverage early due to that notice 2029? And again, talk to your TPA about how that is handled and whether or not there is a termination or a reduction in the election amount and how that is actually being handled with the TPA. But they would not be entitled to COBRA because if they've opted to terminate the coverage, then that would not be a COBRA qualifying event. I will tell you, most of the TPAs did not terminate the coverage on FSAs. They just stopped the contributions because you didn't want to have a situation where the employer may have elected 2,400 and it only contributed, maybe 200, and then they come in and they said, hey, they want the full amount to be terminated. So usually it only went to the amount that was remaining that hadn't been used or underspent and everything else. So there was quite a bit of complication here. So again, I would talk to your TPA, but again, COBRA would not be something that they would have because it would be voluntary. So one of the questions that the employers always ask is, should I allow for any of these changes? I don't have to allow them. Should I allow them? And what would be the options if I do? Well, the first thing I always ask is, do you live in a state mainly, or participants live in states that have certain degrees of lockdown? If you're in a state that's pretty wide open, Georgia, Florida, at this time, maybe there's not a need to do a lot of this, except if you have a lot of employees that are fearful or are older and are fearful about getting out. And then you always look at the plan, whether it's a calendar year plan. One of the things that we did at Medcom, we are a calendar year plan, and we were looking at whether or not we should allow the carryover for 2020 to go into 2021. Well, what is the first thing we wanted to do? Did it affect anyone? So we ran a report. And in that report, we wanted to know if anybody was over the 550 left in their FSA account. And should it be something that we look at for these employees? And if it was only a question of a few dollars and cents, would it be worth it? Because, you have to amend plan documents and all that. But we found 4 of our employees had quite a substantial amount of monies left in their FSAs. And because it was a calendar year plan and we had already run through the calendar year, they had already contributed the full elected amount. So we said, yeah, let's let them carry it over. It made good sense. And then is there a TPA handling fee for this? How does the TPA handle it? So you might want to check on that as well. And do you want to do for 220 now and then wait to see 2021 until where we are at that point before making a decision? You can do that as well, because basically any of these things can be done at any time during the year. They didn't have to be done day one. So at that stage of the game, that ends my presentation. And again, there's a lot of this stuff that is still up in the air and that we just don't know. Because we didn't have any advice from the agency. So everyone is just kind of trying to fly by the rule of law, the way precedents are usually made, and also what the actual statute said. So at this stage of the game, do we have any questions, Casey?
We certainly do. We already have a handful of questions that have come in. So while we're going through these, if you guys have any other questions, go ahead and feel free to submit those into the questions panel of GoToWebinar, and Michelle and I will cover those before we leave today. So the first question we have, Michelle, I had a member elect COBRA paid for 1 month. then was termed from COBRA vendor because they failed to pay in a timely manner. If the member decided to go back and pay back the payments, must the carrier add retroactively?
The carrier should add retroactive, yes, because of the outbreak period. Now, so that is something you have to consider. The only thing is, if you're a public entity, the outbreak period was not affected for a public entity. So if you were a school board or not a private employer, then the outbreak period did not apply. The Department of Health and Human Services recommended that all public health or all public employees adopt the same method, but it could not force them to do so under the PHSA. So unlike ERISA, where there was more clout, there wasn't as much clout under the public sector. Sorry. So again, the carrier should, yes, go back and do that.
Thanks, Michelle. Next question. Does an employer need to provide a qualified beneficiary with notice if they are going to stop covering the COBRA cost for someone who stopped paying during the pandemic?
That is a really good question. I will tell you that the Department of Health and the Department of Labor, the same time the outbreak period came out, they put out a model notice, first new model notice in years. And we thought, oh, this is great. They're going to give us some model language as to what we need to let the individuals know. And when we looked at the model notice, it just clarified some things on Medicare and had absolutely nothing to do with advising employees of any or qualified beneficiaries of any of this. So there was no real guidance from the Department of Labor. However, if you look under the plan fiduciary duties, where it says that plan administrators will administrate the plan in accordance to the best interest of the plan participants, we believe that that was where it was kind of mandated that you do send some kind of notice explaining the outbreak period and explaining the period of time that you would have to then catch up with your premiums. So Medcom did advise all of our clients of this and sent out the notices, but it was not because the Department of Labor said we had to. It was more or less under the plan fiduciary obligations. And you know, there's those attorneys out there who are slamming COBRA and trying to find class actions on COBRA. So we think it's always in the best interest of the participants to let them know what's going on. Now, the Department of Labor did have a website for that for their plan participants also, that they could ask, you know, they had a bulletin up about the outbreak period, but they never said anything about providing notices.
Thank you, Michelle. Just a clarification here, for a terminated employee to take advantage of their FSA, if the employer chooses to implement the changes from the Consolidated Appropriations Act, that employee does not need to, that terminated employee does not need to elect COBRA.
That is true. That's true if it's the full election amount. However, I believe that if it's not the full elected amount and that they're only allowing them to use the contributed, the amount that they've already contributed, then if then there could be a loss of coverage of the full amount. And I believe at that stage of the game, COBRA may have to be offered. And again, I say that basically looking at what COBRA law says, and you know, about a loss of coverage, there is a loss of coverage, but we've had no guidance. But it just makes sense that if you don't get the full elected amount, then you do. If you have the full elected amount, no COBRA. If you have the contributory amount only and you're underspent and everything else that generally applies to FSAs and COBRA, you might have to send a COBRA notice.
That makes sense. Thanks for that clarification. Can a dependent care participant receive reimbursements in excess of $5,000 in one calendar year because of the rollover?
I believe they can, yes.
Great, thank you. So Michelle, tell us a little bit about what Medcom's clients are doing. Are they allowing carryover before, or what are we hearing so far?
And our clients, we have a massive array of different things. For 220, we had some of the non-calendar year plans just said, hey, yes, we do want to help our employees out. If you remember, Casey, way back at the beginning of COVID, we used to do a lot of desktop discussions. And the questions with the desktop discussions always were, what happens with the FSA? How can we help our employees with the FSA? They've contributed all this amount and now they can't use it. And what are we going to do? Can we give it back to them? Can we change the election? And at that stage of the game, the law hadn't come out yet that they could, but we kept on advising that we thought it was going to be a year of limited enforcement. And then the law came out and they said you could do this, you could do all these changes. So I think a lot of employers decided that they were good, especially on the non-calendar year plans, really wanted to help their employees out. However, the calendar year plans, maybe not as much because we were waiting to see what was going to happen by the end of the calendar year. And really that 2029 was really for the non-calendar year plans. And then the CAA is really for the ones that were a calendar year plan. And at the end of the year, everything kind of still is blowing up in our face. But we have, I think, a variety of everything. Terminated employees, I don't think is that big of a deal. I don't think there's too many, going to be too many takers on that. I think if the employee terminated and they would normally lose the benefit, I don't think a lot of the employees think that there would be any reason to continue that. But it is an option that they were provided.
Thanks, Michelle. So how is the terminated employee notified that their employer chose to offer FSA to the terminated employees? Is the employer responsible for that?
I think that is typically up to the employer to let them know that they're doing this. I think it's good PR for the employer to do it, but they should talk to their TPA if they want the TPA to do it.
And can you tell me, so the big deal about what makes the difference between if a plan isn't a calendar year plan, just a little confusion on what makes the difference in regards to FSAs.
Okay. If you look at the notice 2029 back in early, probably mid-year of 2020, what they were concerned about was the employees that could not get to the doctors because of COVID. So they said you could use the money to the end of December 31st of 2020. So that if you were a calendar year plan, well, that's when you could use your money anyways. So there was really no need for some of the changes to use the monies that way. They could still allow the employees who to terminate or to change their election amounts, and that affected the calendar year plan. Certainly if somebody wanted, the employer wanted the election amounts to be changed, but for the amount of monies that they could, they could spend it to the end of the year, that part of 2029 really did not make any sense for the calendar year plans. And that's where the that's where the CAA came in. They said, okay, now you got the calendar year plans that have money left over. What can we do for those? So that's when they allowed the carryover to come in. Now they could allow it for anyone who had a plan year that ended in 2020 to carry it over for 2021. But they also had some of the advantages that the others didn't have of the 2020 as well. So, I mean, we're just trying to take care of everybody, but certainly that was one of the big differences. Nobody thought that this was going to go on as long as it has. Does that make sense?
I think it makes sense. Yeah, I think it makes sense to me. I'll wait. If that person has another question, feel free to go ahead and submit that. We have a couple more questions to get through before we reach the end today. Michelle, this is an interesting question. If the FSA plan has a grace period, can you amend the plan to remove the grace period and allow carryover instead?
I believe you can make any amendments as long as it's done before the end of the plan year. That probably doesn't help so much with this. But again, I think this is going to be limited enforcement. But that's typically what that's the typical ERISA answer, is that you can amend anything before the end of the plan year.
I gotcha. Okay. We've had another question come in. I just want to kind of go through part of it. It is a multi-level question. So Michelle, what I'm probably going to do for this today is just go ahead and send this to you after the presentation so you can reach out to the person who asked. But just the beginning of this question here, if adapted by us, would we be amending the 2020 FSA plan to allow for the remaining balance in the FSA account to roll over to the 2021 FSA plan?
Yes, plan documents have to be amended. The good news on the plan document amendments is that you don't have to do them for 2020. You don't have to do them until December 31st of 2021. And for the 2021, it doesn't have to be done until the December of 2022. Reason being is because there might be some more changes, and let's get everything together at once. But the main idea of the IRS is let's get the benefits out there. Let's let everybody know what they have and then worry about documentation later.
All right, thank you for that. And the rest of that question, Michelle, I'm going to put you in touch with the person who reached out, and we'll make sure we get that question answered, and we'll also check into some other things that have been brought up today. That's all of the questions that have come in so far. Just to let you know that we will still take a few questions. I wanted to go over a little bit about Medcom in case you didn't know some of the other things that we do offer. On top of COBRA, Premium Billing Administration, and your consumer-driven health plans, your FSA Independent Care Administrations, we offer ACA employer reporting and penalty appeal support, which might come in handy now that the IRS may be stepping up its efforts to kind of make a little bit of extra money, considering that they haven't made as much for the ACA as they promised. So we definitely offer that penalty appeal support. We also offer a wide range of health and welfare compliance and actuarial solutions, and HIPAA privacy and security solutions and training. So make sure to keep those things in mind. And just want to say another thank you to Michelle for joining us today and offering her expertise. We really, I think, underestimate sometimes how complicated this is for brokers and employers alike. So it's good to have these sessions and good to allow everybody to ask their questions. Please feel free to reach out to us, reach out to Michelle if you think of any other questions today. And just want to thank everybody once again for giving your time to us and trusting Medcom to kind of help guide you through this mess that we are kind of in, and make the muddy waters just a little bit clearer. So thank you so much, Michelle. And thank you to everyone who joined us. We hope you have a wonderful afternoon.
Thank you, Casey.